What exactly is the difference between the earlier version and this new version that has led to this kind of furor?
There is no case of any reverse discrimination. This is just made out without any logic. What about the school sector? They are completely silent. It is so complicated to identify the sphere of discrimination. The equity committee, consisting of some professor, vice chancellor, some students, some civil society organization, they are not competent to make the list. I don't know what is going on there, to be very frank. It is governed by prejudice and at times ignorance.
Hello and welcome to another episode of the InFocus podcast. I'm G. Sampath. Caste-based discrimination on Indian campuses is a social reality. On January 13th, the University Grants Commission, or the UGC, notified new regulations to promote equity and discrimination students from SC, ST, OBC communities and other marginalized categories as well. So these are the University Grants Commission Promotion of Equity in Higher Education Institutions Regulations 2026. Now these regulations are an updated version of the UGC's campus equity rules originally passed in 2012. This revision was the outcome of a Supreme Court order last year. But the new rules have sparked a wave of protests from the upper castes, and the Supreme Court was quick to pass a stay order. So why were these new regulations passed in the first place? Why are Savarna protesters opposing them? And do their fears of reverse discrimination have any merit? And was the Supreme Court justified in its stay order? We dig into all these questions in this episode of In Focus, and joining us today is someone eminently qualified to speak on this issue. We have with us former chairman of the University Grants Commission, Professor Sukhadeo Thorat. Professor Thorat, welcome to InFocus. Thank you so much for joining us. This UGC Campus Equity Rules, the 2026 version, sir, they are an updated version of the 2012 regulations. So can you give us some kind of historical background and context? What brought the 2012 UGC regulations for promoting equity? What brought them into place? And what led to their being updated into this new version, which was notified on January 13th?
The background to the 2012 regulation is that although there has been a cases of suicide, but the two cases in All India Institute of Medical Sciences in 2008 and 7 led to some kind of agitation and discontent among the scheduled caste student in the All India Institute of Medical Science. The Principal Secretary of Ministry of Health and Family Planning approached me to chair a committee to look into the reason of this suicide, which I did. And after having sort of studying the situation, canvassing the questionnaire, seeking the responses from the student, I brought out the report, which revealed a significant degree of discrimination of the scheduled caste, scheduled tribe student, by the teacher, and even administrator in different sphere, in classroom, in laboratory, in evaluation.
What forms did this discrimination take? Was there segregation of educational spaces and so on? Like what kinds of discrimination in specific terms happened?
The kinds of discrimination happened differential treatment by the student in sharing the information about the classes. The high caste student who are head of the class. The discrimination felt by the scheduled caste student, teacher not giving them enough time and or appointment as they required. The access to the laboratory has been one of the issues. But many complained about the discrimination in evaluation, in examination, particularly in interview and written test. So this was as far as the academic part of concern. But there was equal pattern of discrimination in the social life on the campus. In the hostel, because the rooms are allocated randomly, so scheduled caste student happened to get a room in the wing where majority of the students of the high caste. So they face harassment. The room of one or two students were locked from the outside. Then some filthy things are written on their door. So the scheduled caste student, under the facility of change of the room, will eventually change the room and go to the wing where there are majority of scheduled caste students. In the dining hall, there are private dining hall now, so there is segregation in dining hall.
Segregation in dining halls.
Yeah.
That's like classic untouchability kind of
Segregation in the
situation.
dining hall, in the sense that the scheduled caste students sitting separately, eating separately, because they're being non-vegetarian. So that's one aspect. But there are private, the students have their own private mess facility. So those groups are forms. They put the resources together and they cook. Somebody cook for them. So there it is on the pattern of caste. Similarly in the sport and cultural events. So and then of course the behavior, the quota student, the government ki jawai. So some of these humiliatory behaviors, and of course in the peer group and friendship group, they get confined to the caste. So this was the nature of discrimination, which the AIMS faculty protested that they think that no, it doesn't happen. But they took some positive decision, only in few spheres, not many. And then again, after a year or so, there were two more suicides. I think one in JNU and one at other place. Then the Kapil Sibal came as education minister. And I was sort of pursuing this. Report became very known and got a lot of publicity. So I was pursuing to have some regulation. So it's Kapil Sibal who took the initiative, and in fact, my term was over. He asked me to prepare the list of the forms of discrimination to be included in the regulation. And
this was in which year, sir?
This is 2012, 11-12. That's how the regulation came. Now the 2026 has a history in the sense that the suicide happens. Vemula in 2017, I think, 17-18. Then it was followed by Tagdi, and then 2023 Solanki in IIT Mumbai. So these two mother, Vemula's mother and Tagdi's mother, went to the Supreme Court in 2019. Seeking the proper implementation of the 2012 regulation. They argued that despite the regulation, the suicide has not been stopped, and the reason behind suicide has been caste discrimination. And you had a regulation against caste discrimination. So the Supreme Court summoned the UGC. Disha Wadekar took the case. Indira Jaising was also there on their side, and Disha Wadekar also was one of the petitioner. And then UGC, the Supreme Court asked UGC, and UGC then wrote to various colleges and the university whether they had set up a equal opportunity cell. There is a provision of equal opportunity cell as an administrative mechanism, and how many cases are registered under discrimination. So they many didn't responded, but they found that more than half of them haven't set up the cell, and the complaints are not entertained properly. They are sent to the counselor. So then UGC asked the government, Supreme Court asked UGC to take necessary step. In response to that, UGC said that we are bringing an improvement in the 2012 regulation. So they brought out 2026 regulation in January 2026. That's the history of this 2006 regulation that we have today.
Thank you so much for the background, sir. Really appreciate you sort of bringing it so much with so much clarity. In response to the 2012 regulations, I don't remember hearing about a lot of protests, but the 2026 regulations, the version which came out on Jan 13th, has led to a lot of protests by Savarna groups, by upper caste students. What exactly is the difference between the earlier version and this new version that has led to this kind of furor?
One can understand it from the petition on the behalf of the agitators. 3 lawyers have filed the petition in the Supreme Court, and from that what is understood is that the first objection is that there is a special mention of caste discrimination of the scheduled caste, scheduled tribe, and OBC. And they say there was no need of special mention of caste because there is a general provision of discrimination and exclusion. So caste could have been included in that, or caste is already there, it is already covered. Why do we need a special mention of caste? Then in 2012 regulation, the caste discrimination was confined to scheduled caste and tribe. In 2016, they added the OBC. This is one thing. And by mentioning the caste discrimination separately, they argued that this might lead to reverse discrimination, and this goes against Article 14 of equality before law. And they also say that ragging should have been brought under the purview of this regulation. These are the three major arguments of the petitioner on behalf of the agitators.
Right. So this question of this concept of reverse discrimination, what does it really mean? For the way one understands, if we apply the same logic, is it possible, for instance, that persons with disabilities will discriminate against able-bodied people, for instance? Well, how isn't any kind of discrimination an outcome of a power differential between two different sets of collectives, which is why you have racism, for instance, discrimination on the basis of race. So it's like saying the oppressed will discriminate against the oppressor. Like how does the reverse discrimination really work? Does it have any kind of meaning to it? What does it really mean?
In addition to caste, these general provision have religion, race, color, physically handicapped, and including OBC, of course, and also economically weaker section. So all are covered. Now the discrimination, never discrimination concept, in fact, what has happened is that there is a provision of equality before law and opportunity in Article 14. Article 15 prohibits discrimination based on caste, religion, color, origin of the place, and all that. And that then there was a provision of reservation. I think the first amendment of the Constitution was that if you are giving reservation to some, then that is a reverse discrimination. You are discriminating the other by giving them quota and not appointing others on the basis of merit. That kind of thing. And therefore, the Article 16 came, which empowered the state to take policies in favor of those groups who are underrepresentation in government services and who are educationally and socially lacking behind. So that was the provision at that time. Now the argument here is not understandable. It is not a valid argument. You have a provision of Article 15 that nobody should discriminate against anybody based on caste, religion, race, and all that. And then you have Article 17, which debarred practice of untouchability and make his subject to punishment. So these are the provisions in the Constitution. Then the government has given a safe convert that provision into a law. So Untouchability Offence Act of 1955, Atrocity Act of 1989. Then you have Act under sexual harassment of women. Then you have Act for handicap. So for every deviation from the Act, normal thing, you have a Act. And and those who indulge into violation of the Act are subject to punishment. There is no case of any reverse discrimination. This is just made out without any logic.
What about the other point?
There is the other thing is that false case, for example. Now, as you rightly say, the scheduled caste, scheduled tribe students are so weak, they cannot courage to file a false complaint against the powerful high caste student. So that argument is not also correct of misuse of false cases.
Doesn't this entire argument about misuse of the law, does it not arise every time you have a kind of an asymmetric legislation where you are trying to bring in equity through identifying a particular targeted community in law? For instance, even in the domestic violence legislation, for instance, even there is this narrative of it being misused by women against their male partners.
Yeah, the point is that this argument of misuse is there in male partner. This is in case of scheduled caste, scheduled tribe. The point is that there is a process of law that if somebody files a complaint, there is a committee or there is a court which examine the validity of the arguments, and they require a reasonable evidence, and so that it is proved that beyond reason something has happened. So there is a process of law. Now, in case somebody feel that the somebody lose the case, complainant lose the case, and if somebody feel that he or she has been defamed, then there is a alternative for that person to file a case against a person under the IPC, defamation. So there is that window open to them, but you cannot say that there should not be a law at all against discrimination. That will be very obnoxious kind of a argument. If there is a discrimination, there has to be a legal safeguard, and there has to be protection also against if there is a defamation and all this. There is a provision already there. Or even a student, who has not been found to be, where it has not been proved that he has not indulged to discrimination, he can file a complaint to the university that this person should be punished because he has his argument were not correct. So committee can set up and look into it. But you cannot say that there should not be provision against discrimination at all. This is this tendency which has cropped up very recently, that we don't want to bring out our dirt of caste system and untouchability in open.
So one of the key differences between the old version of these regulations and the new version is that the new version has certain provisions to make those equity regulations enforceable. They have this equity committees which universities and colleges have to set up, and if they don't set them up, and if they are not in action when required, then there is a non-compliance clause which can be used to sort of suspend the accreditation of the universities and so on. Do you think these are like good provisions to have, and are these one of the reasons why now that there is a real quote unquote danger of these regulations being implemented, that they are a cause for concern among certain sections?
From the petition, it is not in the petition. This has not been mentioned. It was the suggestion of Disha Wadekar, who suggested that the fact that the half of the education institution has not set up the equal opportunity office, which means that there is no deterrent against them. So she has asked that there should be some enforcement by the UGC, and therefore there is a provision that the education institution should set up equal opportunity office as a part of that set up equity committee, and develop a mechanism for enforcement. And the UGC should also have a overall supervision. So it is because of that, I think the UGC itself has made that provision of making the education institution accountable. But my feeling is that they have all borrowed it from this. There is also a provision of equity squad. Some person in each of the department will be in charge of watching the vulnerable areas where discrimination is likely to happen. These all they borrowed from the Ragging Act. Under the Ragging Act, the mechanism is not set up and complaint is not entertained. There is a punishment to the institution, withdrawal of the grant and withdrawal of the right to award degree and all that, whatever. I think the state were borrowed it from the Ragging, and but it was demanded by Disha Wadekar. This was one of the weakness. Then there was other provision there in the 2012 Act that if the somebody has to make a complaint against the somebody has to appeal. He or she can appeal to the head of the institutions. So Disha Wadekar pointed out that if there are complaints against the head of the institution, how can he have a head of the institution as a authority? So she asked there should be either a chancellor or the president or a ombudsman authority where you can appeal, but not the head of the institution. Now that provision has been brought into this regulation 2026. So there were a number of suggestions in the by Disha Wadekar. But despite of that, there are also negative aspect of 2026 regulation, which I have pointed out in the article in Hindustan Time. Is there are 2-3 of them. One is, of course, that there is no clarity on the number of type of institution to be covered under this regulation. At one place is mentioned the higher education institution, but when they define education institution, it's define educational institution as those university and the colleges which are included under section 3 of the UGC. And section 3 of the UGC means all university and colleges which are registered, they are listed in that. It is called 2A clause. And there is also a 12B clause which the institutions are included in that list, which entitle them for a grant. Which means indirectly that you have an institution which are not under section 3 of the UGC. You have IITs, IIM, and standalone institutions. IITs are set up as a national institute of importance under the IIT Regulation 61 and IIM 2017 retrospectively. Standalone are under AICT. Then we also do not know to what extent the agriculture universities and agriculture colleges which are under the Indian Council of Agriculture Research will be covered. To what extent the law university and law colleges which come under the Bar Council, to what extent the medical university and colleges which come under the Indian Council of Medical Sciences, and then there are a host of others, dental, pharmacy. What about that? So
you're saying, sir, in that case, that these regulations over which there has been so much of protest, they will not apply to IITs, they will not apply to IIMs, they may not apply to agricultural universities, they may not apply to medical colleges, they may not apply to law colleges. All of these are, as per this draft, already out of these regulations. Is that what you're saying?
So I cannot say with confidence because they say at one place they say all higher education institution. At other place they say institution which are under the section 3 of the UGC, and they don't mention. They talk about universities and the colleges. Now IITs and IIM, they are not universities; they are standalone institution with a degree awarding right. So there is a lot of confusion there, and there is no clarity. Therefore, I suggested the other day is that this law regulation should not be brought by the Ministry of Education. This should be brought by Government of India, and indicating that all education institutions under whichever ministries they are, they will be included. For example,
But did you mean to say, sir, that this should not be brought by the UGC but by the Ministry of Education? Government of India?
No, not even by Ministry of Education.
Okay.
Because there are education institutions under Ministry of Home and Defence. National Defence Academy Pune is under Ministry of Defence. So, and there are Sainik School and other thing which offer diploma. My suggestion will be Government of India, covering all ministries and covering all institutions under irrespective of any ministry should be covered under this regulation. So that will be in complete clarity. The second limitation, Sampath, is very, very, very important, is that 2012 regulation lists the forms of discrimination. What behavior of the high caste or anybody will constitute discrimination. So there are about 28 forms of discriminatory behavior which have been listed. The 2026 regulation has taken them out.
They have been deleted from the draft.
They completely deleted. They say that there is a general definition of discrimination and the university can consider under that definition. It says that, in fact, it says that the equity committee should make the list. Now, it is so complicated to identify the sphere of discrimination. The equity committee, consisting of some professor, vice chancellor, some students, some civil society organization, they are not competent to make the list of the forms of discrimination. I will tell you the story that we have Untouchability Offence Act, which lists about 20 forms of behavior which constitute discrimination associated with untouchability. It took a lot of time to the government to identify those forms. Similarly, the Atrocity Act of 89, in the beginning there were about 20 to 20 forms. Then over a period of time, they found that there are other forms. So the amended Act of Atrocity Act, the 2015, has now 40 forms of atrocities. So Supreme Court in one of its decisions says that the atrocities are crime which are very unique. They are different than that under IPC. Now, if this is the nature of discrimination under untouchability, is very contempt, humiliation, using all kind of derogatory and mean behavior. I think you should have a look at their private surveys conducted by the IIT Mumbai, and brings out very vulgar forms of the behavior of the higher caste towards the scheduled caste student. Beside calling them quota and government ke jawai, but there are other forms which I don't feel like sharing with you. So if that is the nature of this, my suggestion would be that government of India, when they have this regulation, make a list through an expert committee. They have the Anti-Untouchability Act, they have Atrocity Act, they have a Sexual Harassment Act, they have certain regulation for the physically handicapped. So take all that account, and for each of this category they can mention this, and then make it applicable to all the education institutions. You cannot leave out to the individual universities. There is other danger there. Each individual university equity committee will list, for example, and the other may not. So one form of behavior will be discriminatory listed under one university, other will say no. So legally it will create a huge confusion. So this is a major limitation of this 2006 regulation. The third is, there with this equity committee, which will consider complaint and take decision, recommend to the head of the institute. The vice chancellor and the principal is the head of that committee. So now the decision is to be taken by the head of the institute, and the head of the institution is also sitting in the committee who will make the recommendation. He's sitting on both sides of the table. He make the recommendation, he also considered. So that's not correct. So I have.
So are you saying that the head of the institution should not be there in the equity committee? Like, how would you have the composition of the equity committee? Who should be there in the?
No, the rest of the composition is okay. It should be there, but the chairman should not be the head of the committee.
The equity committee, as per what I've seen on in the legislation, in the regulations, it doesn't really specify a fixed percentage of representation for SC, STs, OBCs.
That is also there.
May have just one or two. The majority might be upper caste.
They say the representation for SC, ST, OBC, but they doesn't specify the quota. I have recommended that at least half of them should be out of 10, half of them should be the from these three categories. So these are several, the 4-5 limitation. But one about which I am very much disturbed, and I have written about it. What about the school sector? They are completely silent, not even talking about it. I was the chairman of the Karnataka Higher Education Commission. I submitted a report, and we have suggested the moral education course, constitutional value moral education course. So I set up a committee to look into the forms of discrimination under Satish Deshpande, and I asked him to study the discrimination in the school. It comes out that there is a rampant discrimination in the school sector. Otherwise also, the study that we have done, and Indian Institute of Dalit Studies, there is a discrimination in the midday meal. The Dalit woman cannot be a cook. Very difficult. There are complaints. The high caste student would not eat. Then in the midday meal, the high caste student will eat first, and scheduled caste student will eat later. In Bihar, everybody knows that in a school, primary school or middle school, scheduled caste children sit separately, high caste children sit separately. Sweeper are at times student from sweeper community are asked to clean the toilet. So the student cannot say anything. They absorb it and is quietly. So the government of India is I am so surprised and shocked that they are just sitting on it, only higher education, because there are suicide cases there. That should also be brought in. There should be a separate regulation for equity regulation for the school, and there the forms will be different, the method will be different. The teacher, the 1 year student, 2 year student, second, third year student standard, they cannot make a complaint. So you have to have other mechanism whereby you get to know the forms of discrimination in the school sector.
Do we have any kind of a template for schools? This kind of a
Yeah,
regulation?
we have done that. For a Karnataka report, we have done. We have made a recommendation also.
And there's been no action on that so far.
Yes, I think Karnataka government is also not, at least higher education, they say it's in progress, but I do not know when they will do it. It's more than 3 months. It's a very good report. One of the best report in my view. I was the chairman. They should put it in public domain also.
Yeah, it should be in the public domain actually. So now the Supreme Court has said that these 2026 regulations are vague, sweeping. They could be misused, and it has passed a stay order on them. So what is their rationale in staying these regulations? Like, if the Supreme Court seems to think it's going to be misused, does this mean that it doesn't have faith in the legal process, that it can be easily manipulated by anybody? What does it mean?
What they have said is it's vague and misuse. It's vague, and that is why it may be misuse. I don't think they are saying that there will be a the false complaint or other. They are not using the misuse in that context. Misuse says that if the law is not clear, there is a possibility of double interpretation. I think I have a feeling they are using in that sense. But the other things are which are unexpected from the judges. The comment that they have made, they amount to supporting the petitioner. The comment they have made that rigging should be brought in under this regulation. And they have directly supported that if the caste clause is mentioned in the overall normal clause, why there is a necessity of a separate clause. And they have also said that it will lead to divide. They are almost agreeing with the petitioner, which they should not do that. That was very surprising and shocking to me. But the Sampath, the most disturbing phenomena is that I think the Indian Express carriage is that they have put 5 questions. They will put 5 questions before the committee and consider on 19th of March. The two, of course, are the objection raised by the petitioner. One is that caste should not be mentioned separately. It should be a part of the general definition of discrimination. Second is the ragging should also be brought under this. Then there is a third. I don't know where did this came. It came from the sky. This came from the mind of the judges. That the harassment of the high income group of a scheduled caste of the low income group. Nobody has made this argument. It has never happened.
Sorry, harassment of the high income group of
scheduled caste student to harasses the low income group of scheduled caste, and that should be examined. Obnoxious suggestion. This is not again a identity based discrimination. You must understand one thing, that the discrimination is based on social identity, group. It is not individual discrimination. Now, this is not based on the identity, and if there is a proof that the high caste, economically better off students, scheduled caste students are harassing the low income scheduled caste students, on the contrary, they help them. Then I understood what are they trying to say. They are trying to say that they want to bring the creamy layer. They have been arguing for a creamy layer. So this is an indirect way, backdoor way of highlighting at least some division within the scheduled caste. And then there is other thing also. So I think these are prejudicial and argument of the judges, and even saying that caste should not be separate. See, my position is on caste. Caste should be separate. Untouchability be separate. They should be included in the general provision of discrimination, but at the same time, they should be maintained separately. In fact, I would argue that each of the category, the scheduled caste, the OBC, the scheduled tribe, religious minority like Muslim and Christians, physically handicapped, low income group should not come there. Low income group is not doesn't face discrimination based on social identity. There should be some earmarking of the economically weaker section, but bringing them under a reservation was a absolutely wrong decision of the Supreme Court. I would suggest that while there should be a general provision of discrimination under which all category are included, but the nature and forms of discrimination of each of the category is similar but also different. So this should be listed separately also. See, let us take OBC. OBC suffered from caste discrimination in terms of denial of equal right. They did not have right to property, they did not have right to education, there are restriction on intercaste marriage, social relation, discrimination. In AD 1700, then they got right to land also. So that is why they are OBCs are mostly farmer. So caste discrimination, that is denial of property right and other social right, is the feature of Shudras. Same discrimination is faced by the untouchable, but there is additional disability faced by the untouchable, that is they are considered impure and polluting, and that is why untouchable, unseeable. So there is a difference between OBC and scheduled caste. So their disability should be listed separately. Similarly, disabilities of women. The women did not have right to education, right to property. So they are similar to Shudra and to some extent untouchable, but they don't suffer from untouchability. Now, as far as religious minority is concerned, we don't have information. There are no study what form of discrimination is faced by the Muslim and the Christian. There has to be proper study. So there has to be a list of the forms of discrimination separately experienced by each of this category, while you can have a common definition also. So the judges have agreed with the petitioner that they should not, caste should not be mentioned separately. 2012 regulation mentioned it separately. There is a separate provision in the Constitution, Article 17, which ban discrimination about untouchability. And judges are saying like this. So I don't know what is going on there, to be very frank. It is governed by prejudice and at time ignorance.
Just to take the petitioner's point at face value, I have to. This is my second last question. Is there a realistic possibility that say a general category person might face some kind of discrimination from an OBC or an SC or ST person, and by virtue of caste discrimination being defined in this way, they may not be able to act as an aggrieved party.
No, I don't understand the argument. The point is that in the 2012 Act, they have identified 28 forms of discrimination. Now, if the high caste student practice those, then it is only then and then they are considered to be subject to complaint. And it is not only the high caste. The OBC, if it practice against the scheduled caste, that will be included. If scheduled, then there is other thing. If scheduled caste, scheduled tribe, OBC enters into discrimination of the high caste woman student, physically handicapped student, even a high caste, they are also subject to punishment. So this provision is inclusive of all social group. Discrimination of high caste by high caste of the others, discrimination by the scheduled caste of the high caste woman and others. This is all inclusive. So the argument that they are making is very political and prejudicial.
We know that the current socio-political reality, what it is, there is a lot of resurgence of what we might call, let's say, regressive forces, not just in India, but all over the world, right-wing forces, which are going back to whatever, some might even say medieval norms of gender, race. And in India, we see caste as well, religion. There are these tribal identities which are taking precedence over the old values of equality before the law, equality of opportunity, gender parity, and so on. So in this kind of an environment, what do you see as the prospects for a progressive legislative interventions coming to fruition? You've seen the Supreme Court's response as well. So is progressive legislation an effective way of addressing ways to sort of bring about some kind of positive changes in society in terms of reducing caste discrimination, etc.?
Well, there are two aspects of it. One is that the Constitution provide certain fundamental rights. Under Article 14, it provides equality before law and equal opportunity. Under 15, it provides a safeguard against discrimination. If you discriminate, there are safeguard. Against caste, there is a untouchability, there is Article 17. Then there are provision against religious minority and even cultural rights. Now, when there are provision, these are only provision, that's all. You have to have a safeguard, legal safeguard against the violation of this right. So that is the normal thing. Anywhere in the world, anywhere in India, that you give the right, but there has to be a safeguard whereby you are able to use those safeguard, use those rights. If somebody obstruct it, then there has to be some way of punishing those who violate it. So legal safeguard, law against violations are very necessary, and we have expanded it over a period of time. It began with untouchability, caste, then gender, then we cover OBC, then we cover tribals and transgender. So all kind of things. Now the Supreme Court even consider EBC under a discriminate category, insofar as they have given the reservation. So you require that. But most important point is that, which Dr. Ambedkar has argued constantly, is that the roots of caste discrimination and untouchability are in religious ideology. Caste system, they are rooted in caste system and institution of untouchability, and untouchability and caste system are the social organization of the Hindus. So it's a religious ideology which laid down the rules of behavior between the groups. So since it's a religious ideology, religion is always a matter of faith, and people practice the caste system and those customs as a religious principle. Now, therefore, it is very difficult to remove. Dr. Ambedkar has said that the slavery was abolished, and you don't have a traces of slavery in USA. Untouchability was abolished in 1955, and you have untouchability all the way in a significant way. That is because the roots of the untouchabilities are in religion. People observe it as a religious practice. In fact, when the constitution was in the making of the process, there were religious organizations, 4 or 5 religious organizations, who were asking that don't interfere into our religion. Don't have provision with respect to religion in the constitution. Really, there should be a separate organization of these. And in the religion, they include caste and untouchability. It's a caste and untouchability is our the part of our religion. It should be maintained and it should be retained. So you can see that, and that is why it is practiced. Now the point is that since it's a religious ideology, Dr. Ambedkar argued against it at the religious level. So he brought he went to conversion to Buddhism, and there are several movements against the caste system, religious movement. Now in recent years, last 10 years or 15 years, or you can go to back in 100 years, the moment that we had in favor of equality, against inequality, in favor of freedom, against caste restriction, in favor of fraternity, against anti-social caste attitude in the caste system, hatred, contempt. And we condemn caste, we condemn untouchability. For the last 15-20 years, the ideology of Brahmanism is emerging, which indirectly and directly provides support to the social organization of Hindus, namely the caste system. The Shankaracharya has openly said that Varnasrama Dharma is our is social organization, and that should be the basis of the Brahmanism should be the basis of the constitution. So Varnasrama will also be there. They say that you have reservation simply because they are provision in the constitution. So there is a tendency to justify caste system. There is a tendency to base the constitution and the nationhood on the principle of Brahmanism openly. And RSS chiefs say that it is already in Hindu Rashtra. You don't require whether you put a word Hindu in the preamble or not. It's a Hindu Rashtra. So, so that is a very discouraging thing with that happening. And my feeling is that this protest against this regulation, 2060, since it doesn't have any justification in the regulation, it's more a outcome of that kind of thinking. It's more political and ideological rather than legal.
Right. That's a very thought-provoking note to conclude on, Professor Thorat. I mean, you're saying that the protests against the 2026 regulations are more an expression of a certain religiously rooted ideology with regard to caste, rather than what is actually there in the regulation itself in terms of its text and provisions. That's something to think about. Thank you so much for joining us in this podcast. It was a pleasure listening to you, talking to you. Thank you so much.
Thank you very much.